issues that face Santa Barbara area businesses as they reopen. So mark your calendars. That's going to be a very timely and informative seminar. So let me go ahead and introduce Brad Lundgren. He's a partner at Allen & Kimball. And his practice mainly encompasses a really broad range of real estate and business transactions. He focuses on purchases and sales, leases, co-ownership arrangements. He does title evaluations, due diligence investigations, financing. He's been involved in low-income housing tax credits and homeowner association law as well. So he's been representing clients in connection with construction and development matters as well, and also assisted his clients with the selection, the formation, operation, and transfer of all types of business entities. And then Ian Elsenheimer is an associate attorney at Allen & Kimball, and he takes great pride in his ability to deliver innovative and cost-effective legal services to all of his clients. So he practices both transactional and litigation, and his clients receive really comprehensive and well-seasoned solutions to all of their legal issues. What we're going to do is have a Q&A at the end of the presentation. Presentation will be approximately 30 minutes. You can go ahead and post your questions into the chat room, and then we'll go through those and get to as many as we can before the seminar ends. So just hold your questions to the end, and Brad and Ian, take it away.
Thank you, Janet. Well, we appreciate the opportunity to present to you today. Hope you find this informative and helpful. As Janet said, my name is Brad Lundgren. I'm a partner at Allen & Kimball. I head up the real estate group at Allen & Kimball. Just a little bit about our firm. We're a civil firm. We handle, other than real estate and land use, we also address business and business entity and planning matters. We also have a significant estate planning, trust administration and probate department, as well as litigators who handle disputed matters when those things arise in those areas. One of the things that we think is relatively unique about ourselves is that we take a team approach. We view ourselves as a true firm, not just a collection of sole practitioners. And what that means to you and our clients is that we'll tap the resources of all the attorneys in different departments on any given matter, so we can, you're not just getting one attorney, but you're getting the expertise and knowledge of many, and we will delegate our work accordingly so it's handled efficiently. So you may come in for a real estate purchase, let's say, but might draw on the expertise of our estate planners for tax or maybe vesting issues, or if something might be disputed, we'll consult with our litigators as the matter progresses. So anyway, that's kind of how we handle things, and we hope to have the opportunity to work with many of you in the future. So anyway, that's our firm. Our topic today, how do we come over this? You know, we've all been dealing with, we're I think day 66, 67 into the quarantine shutdown now. And I know we've all been dealing with that in our own ways. I know that in my practice, I think one of the hot topics, or the kind of the most significant issue that's come up as a result of this, are landlord-tenant issues, and particularly, what do we do with payment of rent? And why is that? And I think the reason is because this pandemic has really hit at the heart of the landlord-tenant relationship. I mean, if you think about it, what is a lease? If nothing else, it might cover a lot of things and have a lot of issues that come up in the course of the lease, but fundamentally, what is it? The obligation of the landlord is to provide quiet enjoyment of the property or the lease premises in exchange for the payment of rent or the receipt of rent payments. Conversely, a tenant, their basic obligation is to pay rent in exchange for the use and quiet possession of the property. So when you have, back in mid-March, when the quarantine and stay-at-home orders went in place, you basically have a couple things happening. One is that some businesses are either forced to shut down, or to the extent that they can continue operations, you know, they have they're doing so at a reduced level. Maybe their customers can't come in or don't want to come in, and so basically, as a result of those businesses slowing down, their employees lose their jobs or maybe underemployed, and so that creates certainly an inability or difficulty in paying the rent. And not only that, but then also because, at least from a business or commercial context, when you're not able to use your premises, you don't really want to pay rent for something you're not able to use or not able to utilize fully. So, this pandemic has really created a problem that really hits again to the heart of the landlord-tenant relationship, and it creates a conflict there. So the question then comes up, at least from a legal standpoint, how do you address that conflict and how do you resolve it? There's several ways to do it. Obviously, we have a pre-existing body of law. You look at the lease agreement. You might look to the statutes that are in place, and then there's obviously years and years of common law that has developed to the courts over the years. So that's kind of one place you look. The other thing that's happened over the last few months is that the governor, and there's been legislative actions, and the governor has issued executive orders that try to address this specific problem. So that's another area that might be relevant. And I think that we'll continue to have ongoing legislative actions going through the whole course of this pandemic and even likely beyond that. So those are the things that we will look at. I'm going to focus on myself the contractual lease provisions that might impact the question of payment of rent. And then Ian is going to turn to and summarize some of the legislative actions that have happened over the last couple months. So getting into the question again. So why is it that we want to look closely at the lease terms, or why is that important? Why do we start our analysis there? Obviously, there's a statutory framework and a breadth of statutes that apply to the landlord-tenant relationship. They cover a broad variety of issues, such as termination of tenancies, limitations on increasing rents, security deposits, when you can use them, how they're returned at the end of the lease, assignment and subletting issues, and they even discuss habitability standards and other functional requirements of the property. So that obviously touches on a broad variety of issues. However, those are, by their nature, of limited nature. There's only can cover a finite amount of things, and so the lease agreement is there available to the parties to cover those things that aren't otherwise covered by statute. The other issue that arises is that the statutory provisions in the Civil Code generally only apply to residential tenancies. So if you're dealing with commercial tenants and commercial tenancies, those provisions largely don't apply. So your bottom line is that your lease is really the primary governing document for that landlord-tenant relationship, and those lease terms are going to apply except to the extent that they're contrary to law or public policy. So you always want to look at the lease terms and what they say in analyzing what those obligations and rights of the parties are, and particularly with respect to whether you have to pay rent under a pandemic sort of situation. So I'm going to turn to that, and now look at, there's a few there's a handful of provisions that might typically apply, I think, in this context. I'm going to focus on a few of them, a couple of them in a little bit more detail, and given time constraints, I can't really go through all of them in a lot of detail, but I'll touch on them, and hopefully by going through this, you'll get a sense of the type of analysis that might go into this, and that will apply to some of the other provisions we don't quite get into as deep on. So let me here share my screen. And so here, one of the first clauses you're going to want to look at is damage or destruction to the premises. And the question here is, has the virus somehow damaged the premises to an extent that would relieve the tenant from paying rent? So one standard clause is AIR paragraph 9.6a, and I've highlighted here the key provisions. And what it says is, in the event of premises partial damage or premises total destruction or a hazardous substance condition for which the lessee is not responsible, the rent payable by lessee for the period required for the repair, remediation, or restoration of such damage shall be abated. So that sounds like a good provision for the tenant. It says that if there's some sort of damage to the property, that we don't have to pay rent for that period. Now, the problem here is that you need to certainly satisfy at least for the AIR provision, you need to satisfy the definitions for damage or substance condition. Now, in terms of damage, and again, I've listed the applicable definitions down here. Basically, for damages purposes, damage is defined as damage or destruction to the improvements on the premises. So the question that's going to arise from a tenant standpoint, though, is has the virus actually damaged the premises or the improvements they're on? Generally, damage is thought of in terms of fires or floods, or I guess you're in other parts of the country, a tornado or something like that, that changes the nature or structure or tears them down. So they're no longer existing. Here, obviously, those improvements are still standing on the property, and they're their same basic form. It's just that maybe there's a virus there that's somehow there in the space. So is that actually something that's going to be considered damage? I think generally the way this provision might read is that it's probably not. The more likely scenario, I think, is that the virus might create a hazardous substance condition. And as you can see down here, the hazardous substance is defined as, in paragraph 6.2a, the hazardous substance is defined as any product, substance, or waste whose presence, use, manufacture, disposal, transportation, or release is either potentially injurious to the public health, safety, or welfare of the environment or the premises. It goes on, it has a few other things, but that's something that I think a tenant might be able to make a good argument for, is that the virus is a substance and it's potentially injurious to the public health or safety. And so you might have a tenant make a claim that, hey, the property is damaged because there's a hazardous substance there. The problem you might run into, again, from that argument is that if you go on and typically a hazardous substance, I think generally is considered to be something like oil or chemicals or other sort of manufactured products that might be on the premises, and this is not that sort of thing. It's more of a biological agent, or it's something that occurs naturally. The other problem is if you look at the bottom sentence here of paragraph 6.2a, it says hazardous substances shall include but not be limited to hydrocarbons, petroleum, gasoline, and or crude oil, or any other products or byproducts or fractions thereof. Now, that's not necessarily a limit on the types of things that might qualify as a hazardous substance, but generally, as you interpret a contract, you consider the types of examples as sort of the nature of things that might be included. And so again, it leads into that argument that because they're giving these examples of, in this case, petroleum type products, it lends argument that, hey, this is not intended to cover something like a pandemic virus. So anyway, you can kind of see that there's, even though that the basic paragraph 9.6a suggests that, hey, there might be some rent abatement for something where there's some sort of damage to the property, it's not quite so clear cut. If I was a tenant, I might like to make the argument that, hey, this might be analogous if there was some sort of a nuclear catastrophe and something was radioactive. Maybe the structure itself might be still standing, but it's somehow been fundamentally damaged or altered, and so it really does constitute damage to the premises. And so, that might be an argument that a tenant might make here to fall under this clause. The other problem with, from a tenant standpoint, from paragraph 9.6a, is that it says that the rent abatement is not to exceed the proceeds received from the rental value insurance. And so here again, to the extent that rental value insurance is available to protect the landlord, then the tenant can abate their rent to that extent. But on the other hand, if the rental abatement is only covering a small amount, or maybe not, doesn't cover this type of risk at all, then the problem will be that you're not going to, the tenant won't get their rent abatement. So that is CAR paragraph 9.6a. I'm sorry, AAR. The CAR has similar lease provisions, but Here in the commercial lease, paragraph 26, if by no fault of tenant, the premises are totally or partially damaged or destroyed by fire, earthquake, accident, or other casualty, the rent may be abated. And if the agreement is not terminated, the damage is not repaired, the rent shall be reduced. So again, you have in the commercial context, if you can somehow establish that the property has been damaged, you do get rent abatement. But those same sort of issues that applied, discussed under the AIR situation will apply there as well. The residential lease, paragraph 28, again, a similar clause, premises are totally or partially damaged or destroyed, the rent shall be abated as of the date the premises become totally or partially uninhabitable. A little bit different standard there because you're talking about a residential lease. Habitability is really the context. This is less likely to apply, obviously, because residential tenants aren't likely to move out of their premises in this case. In fact, under the stay-at-home orders, they have to stay in their premises, not go to work. So that's the damage and destruction paragraph. Again, you can kind of see some of the issues that arise in that context. Another lease provision that might apply in this context is the force majeure clause. Now, what force majeure is basically when there's some sort of event that might happen that is unanticipated by the parties, that because of the event, the parties are essentially unable to perform their lease obligations, then that party is relieved from performing that obligation. And so that really seems like something that potentially applies here. But in terms of contract provisions, the AAR lease does not actually have a force majeure provision, so that's not going to apply. The CAR form lease does not have a force majeure provision either. So if your clients are using that sort of lease, you're not going to be able to look to that for relief. Now, if your lease does have a force majeure provision, and here is a sample provision here, I'll read it, the applicable portions. If either party is prevented from performing any obligation hereunder by any strike, acts of God, war, terrorist acts, shortage of labor, or other cause beyond such party's reasonable control, such obligation shall be excused during and any time period for the performance of such obligation shall be extended by the period of such prevention. So again, that's the basic concept of force majeure. So the argument here is that, hey, because there's a virus here and this pandemic, we are unable to perform our obligations under the lease, whether it be providing the property for your use from the landlord standpoint or from the tenant standpoint, we're unable to pay our rent. Well, that seems to make sense. The problem, again, here is that really from a technical standpoint, the pandemic itself is not really preventing the parties from performing those obligations. Again, the tenant really is able to pay rent. The virus is not preventing that. You can still write a check and send it in the mail and do those sort of things. The tenant may be insolvent, but that's, again, not really the type of risk that is captured here. I mean, if that were the case, whenever a tenant became bankrupt, they'd have an excuse from paying rent. So I don't know that that's something that is going to work in this case. On the other hand, the landlord, again, the premises are available. The fact that the tenant chooses not to use it or maybe can't use it, that's not the landlord's fault. So that's kind of the position they're going to take. So, again, you've got a problem here, that provision that seems to apply, but it's got some holes on it for both parties. My own personal take on it is that really, I think the fact that the obligations of both parties are really still able to be performed, this is really probably not a provision that's really going to be applicable here. What you're more likely to get, and I'm not going to talk too really about this, but really what there is there's a common law provision or principle, which is frustration of purpose or impracticability, which sort of touches on this, which says that if it's really impractical or parties of purpose to a contract are not able to be recognized, then those parties are relieved from their obligations. And that, I think, is something that's going to apply really more than this force majeure clause. But force majeure is something you hear about in this context, and so I wanted to touch on it and show you an example clause where that might come up and how it might apply. A couple other provisions here that you hear about in this context, business interruption insurance. And that's not really so much of an issue of can the parties perform their obligation, but really is there another set of proceeds that's available to help the parties through the situation. In terms of business interruption insurance, again, the AIR lease, as paragraph 8.4 requires a tenant to obtain it, but as you see, the language here is that the lessee is required to maintain loss of income and insurance in amounts that will reimburse the lessee for direct or indirect loss of earnings attributable to all perils commonly insured against by prudent lessees. And so even though they have an obligation to obtain the insurance, they may not have an obligation to obtain pandemic-related insurance if that's not something that is commonly insured against by prudent lessees. And from what I understand in the insurance industry is that, frankly, at least the insurers take the position that their policies don't cover pandemic coverage. And to the extent it does, it's going to be very expensive. So I don't know that's something that a prudent lessee would necessarily cover. So again, I don't think many commercial tenants would hire or acquire insurance that would cover this risk. As far as the CAR lease provisions, they basically say that the tenants is advised to carry their own insurance. The landlord is advised to carry a rental loss insurance. So again, they're not imposing any obligation on the parties there, but they're just merely raising the issue and suggesting that each party obtain the insurance. Moreover, the CAR lease also contains an express waiver of rights against the other party's insurance. And so if you're a tenant, you don't have right to the landlord's insurance for any remedy or recourse, and same with the landlord. Really quickly, another question that might come up is because these stay-at-home mandates are coming from the government, does that maybe constitute a condemnation of the property? Maybe that's something that might get some traction again. The problem is that typically government agencies have a fairly broad police power rights to protect for the public health, and so this is not necessarily something that would typically be considered a condemnation. Even if it did, it's not necessarily a recourse you would have against the other party to the lease, but it's more of a recourse against the government entity that you'd have to pursue. And so, again, not something that the parties might pursue against each other, but it's perhaps something to think about in terms of if somebody did go against the government, it might be deemed a condemnation, and you might be able to terminate the lease and maybe to some degree reduce your rent to that extent that you're not able to use the premises to the extent that they were condemned. Again, the applicable provisions here from the AIR lease are paragraph 14, and if you're using a CAR commercial lease, paragraph 28, and then the CAR residential lease does not have any sort of a relevant provision in that regard. The last couple things I wanted to touch on real quickly are some other specific provisions that might have some applicability. AIR lease, paragraph 2, talks about condition of the premises, and there might be something specific in your lease that says that describes what condition the landlord has to maintain their premises. And so if there's some specific requirement that's being violated as a result of that pandemic, that might provide some relief to the tenant. In terms of the CAR lease, look to commercial lease paragraphs 11 and 12, or the residential lease paragraph 10. A quiet possession again and enjoyment, again, that's another fundamental landlord obligation to provide the premises to the tenant. The AIR lease, the relevant provision there is paragraph 38, says it's subject to payment by lessee of the rent and performance of all other covenants. The lessee shall have quiet possession and quiet enjoyment of the premises during the term hereof. So if for whatever reason, whether the building gets locked down or it's deemed unsafe to go into the premises, again, that might be deemed a violation of the landlord's obligation under paragraph 38 to provide quiet possession and enjoyment. It might give the tenant an obligation or a remedy to abate their rent. There is no comparable provision in a CAR lease, so that wouldn't help the tenant in that case. Lastly, obviously, attorney's fees is something to consider if you're going to get into a dispute with the other party to your lease. Often, in any sort of litigation, the attorney's fees might match or even exceed the rental amount in dispute. And so you want to know when you're going into those litigation whether you're going to get attorney's fees coverage. And then if you're using a CAR lease, keep in mind that those provisions often have mediation provisions that provide that if a party refuses to mediate, that party, even if they're the successful party, they would lose their attorney's fees clauses. So that's something that could become involved and important if you're get into a dispute over this issue. So again, kind of the takeaways here. A lot of the standard lease provisions, although they seem to apply and might provide some guidance to the parties as to whether they have to pay their rent or not, they're not entirely determinative. They do provide some support to both landlords and tenants in their arguments for their respective positions. I think you want to be aware of these provisions and consider some drafting opportunities for your clients as to thinking about this situation and how you might modify the standard lease provisions to put your client in a better position on those particular issues. And those same arguments and that same recommendation would apply beyond just COVID-19 type issues. So that's sort of a quick overview of relevant lease provisions. I'm going to turn it over now to Ian, who's going to talk about, again, some of the legislative enactments over the last couple months.
Thank you, Brad. And I guess I'll echo what Brad said and thank everyone for giving me the opportunity to present to you guys today. So I'm going to pull up my shared screen really quick. So as you guys heard, I'll be discussing some of the governmental responses to the COVID-19 pandemic. And as you'll see by the slide on your screen, I've broken up the laws and rules that we'll be discussing today into 4 separate categories. First up will be the moratorium on evictions, which will probably take up a large part of the discussion today just because of the numerous laws and rules related to this topic. Then we'll discuss the moratorium on unlawful detainer actions. And then we'll follow up with some topics that are a little bit more tangential to the landlord-tenant relationship, but certainly just as important. And that'll be the moratorium on judicial mortgage foreclosures. And we'll finish up with an overview on the rule that gives the Californians the ability to defer their property tax payments. And while there are a couple other legislative items out there that aren't listed here, like I'm sure you guys have heard of, I hope you have a California Assembly Bill 828, which would give a court the authority to reduce a tenant's rent by 25%. We don't have a ton of time today, so we aren't going to discuss those proposed pieces of legislation. So under the first topic of evictions, we have the CARES Act, which was signed into law by President Trump on March 27, 2020. The CARES Act imposes a 120-day moratorium on both residential and commercial evictions, but only if the property owner's mortgage is backed by the U.S. Department of Housing and Urban Development, Fannie Mae, Freddie Mac, or a couple of other enumerated federal authorities. So if there isn't a federally backed mortgage on the property, then this particular law is not going to apply. But when the CARES Act does apply, it requires property owners to provide tenants with 30 days notice before the tenant must vacate. So this means that under the CARES Act, the earliest day the owner can regain possession is going to be August 23rd, 2020. The 120-day moratorium began on March 27th. That brings us to July 25th. And then plus 30 days for the notice on top of that brings you to August 23rd. Lastly, the CARES Act bars landlords from quote unquote charging late fees and other penalties during the 120-day period. However, it's currently unclear whether or not late fees and interest can accrue during this grace period and then be charged after the moratorium ends. Moving on, we have California Governor Newsom's Executive Order N3720, which was also issued on March 27, 2020. This order establishes a moratorium on residential evictions in the state of California for a tenant's failure to pay rent if the tenant has either 1, lost their job or hours at work due to COVID-19, or 2, had to take care of children whose schools are closed, or a family member that is sick with COVID-19. If the tenant wants to take advantage of the protections offered by this order, the tenant must notify the landlord of the tenant's inability to pay in writing no later than 7 days after rent is due, and must provide verifiable documentation showing that the tenant has a change in financial situation. Importantly, this order and its moratorium ends on May 31st, 2020, so right around the corner. We may see landlords in California terminating tenancies and moving forward with evictions as early as next week, unless, of course, there is some other rule that prohibits the landlords from doing so. Next, we have our local rules. On March 24th, 2020, the County of Santa Barbara adopted its urgency ordinance. And the urgency ordinance establishes a moratorium on the eviction of both commercial and residential tenants if the tenant's failure to pay is directly related to a substantial loss of income or a substantial out-of-pocket medical expense. And of course, that has to be associated with the coronavirus pandemic or any local, state, or federal government response to the pandemic. Under this ordinance, under this ordinance, the tenant must provide written notice to the owner and must have documentation to demonstrate that substantial loss of income or substantial out-of-pocket medical expense. At the city level, we have Santa Barbara City Ordinance 5941, which was recently amended by the City Council on May 19th. Under this ordinance, if a residential tenant provides a landlord with notice and documentation of a significant negative change to their household condition, or a commercial tenant provides a landlord with notice and documentation of an unforeseeable emergency commercial condition due to COVID-19 or a government response to COVID-19, the landlord cannot take any action to terminate the tenancy or evict the tenant. If rental payments are deferred as a result of this ordinance, the tenant must repay the full amount of deferred rent to the owner within 12 months of the ordinance expiration, and that deferred rent shall be paid in equal monthly installments unless otherwise agreed to by the landlord and the tenant. Importantly, this ordinance will expire upon the expiration of one of Governor Newsom's other orders, which is currently set to expire on May 31st, 2020, unless the governor's order is extended past May 31st, 2020, or this particular ordinance is extended by the an action of the city. So that's all I have for eviction-related responses. We'll move on to unlawful detainer actions. And these are lawsuits brought by landlords to remove people from property that no longer, or maybe never even had, a legal right to be there. And as we were going through Governor Newsom's executive order related to evictions, I mentioned that evictions could move forward on May 31st unless there was some other rule that prohibited the landlord or the property owner from doing so. And one such rule would be California Rule of Court Emergency Rule Number 1, issued by the California Judicial Council. And under Emergency Rule 1, unlawful detainer actions filed before April 6th are treated differently than newly filed unlawful detainer. For newly filed unlawful detainer proceedings, a court may not issue a summons on a complaint for unlawful detainers unless the court finds that the action is necessary to protect public health and safety. A summons is the official notice to a defendant, which would be a tenant in this case, that a lawsuit has been filed against them. A lawsuit can't proceed until the summons, that official notice has been served on defendants. So this rule effectively places a moratorium on any court assistance in the eviction process for new evictions, unless, of course, the eviction would protect public health and safety. For evictions filed before April 6th, this rule essentially gives the tenant more time to appear at trial and defend the unlawful detainer. Importantly, this rule will remain in effect until 90 days after the governor declares the state of emergency related to COVID-19, that the state of emergency related to the pandemic has been lifted, or until the rule is amended or repealed by an action of the Judicial Council. Accordingly, even though it looks like many of these eviction protections will expire on May 31st, 2020, courts won't be available to assist in the eviction process until 90 days after the COVID-19 pandemic is lifted or this rule is otherwise changed. This is definitely something landlords want to consider when dealing with non-paying tenants. So now we're going to go ahead and move on to mortgage foreclosures. Currently, the only rule in place with respect to mortgage foreclosures is California Rule of Court Emergency 2. While the CARES Act had some protections in place with respect to foreclosures on mortgages, that were backed by the federal government, those protections expired on May 17th. So moving on to emergency rule number 2, it provides that any action to foreclose on a mortgage or deed of trust, including any action for a deficiency judgment, is stayed until 90 days after the governor declares that the state of emergency related to the COVID-19 pandemic is lifted, or until this rule is otherwise changed. This rule also has the exception for actions that are required to protect public health and safety. And currently, this rule only places a moratorium on court actions to foreclose on a mortgage or deed of trust. So it appears that mortgage servicers can move forward with non-judicial foreclosures like trustee sales, even while this rule is in effect. However, you should definitely consider whether a foreclosure sale, which is supposed to be a public sale, can actually occur while a state-mandated shelter-in-place order is still. Our last topic for discussion today is property tax payment relief. Under Governor Newsom's executive order N6120, it waives penalties for property taxes paid after April 20th, so long as the taxpayer demonstrates they have experienced a financial hardship as a result of COVID-19 or a governmental response to COVID-19. This executive order only applies to residential real property occupied by the taxpayer, or real property that's owned and operated by a taxpayer that qualifies as a small business under the Small Business Association's regulations. This waiver is only in effect until May 6, 2021. So after May 6, 2021, tax assessors can start imposing penalties, costs, and interest on unpaid property taxes. So that's all I have for you guys today. I think we're gonna turn it over to Janet, who's gonna facilitate some questions.
Absolutely. Thank you both very much. It was really, really informative. So a couple of quick questions. Let's just see. Okay, so how can landlords protect themselves as they enter into new rentals and leases going forward? For either one of you.
Well, I think at least from a lease stand context, again, you want to. This is a unique situation, obviously, and the problem that arises is that it's not something that people typically consider. And so to some extent, because you're not considering it, people aren't really addressing it and having a discussion amongst the parties as to what would happen in that context. And so that's why you're faced with problems where the lease and neither the lease or the statutes or other law that applies is addressing this clearly. So people are kind of left in a no man's land. So again, but hopefully you can think about some of the provisions in the lease that are commonly there that I raise, and again, think of how if this sort of situation would arise in the future or similar situations, how would you as a tenant or landlord want to change those provisions in order to better protect yourself? In terms of kind of dealing with ongoing situations, obviously, a lot of people are doing, landlords and tenants are hopefully trying to work things out and coming to some sort of resolution, whether that be giving rent concessions or reducing the rent for a period of time or having something else. That I think is sort of the general approach that most people are taking. Some parties, in particular, I know a lot of landlords take a more hardline approach and just say, well, no, your obligation to pay rent, you got to do it. And so they're not really giving any concessions there. But these things will all play themselves out, I think, over the course of time. And it's really too soon to have any good case law that'll resolve some of these issues. But I think over time, eventually we'll see that. But it's not going to be for some time.
Okay, so another quick question. So what if a tenant does not provide documentation? What recourse does a landlord have? And I think that was in your, I don't know which one presentation it was in about documentation.
Yeah, and so I think it's actually going to depend, what particular law applies to the property at issue. If the CARES Act applicable, I don't remember seeing anything in there about, the tenant having to provide the landlord with any sort of documentation. But if either of those, either the county ordinance or the city ordinance apply, those specifically have requirements that the tenant must provide, some sort of kind of reasonable documentation of that change in financial position. So if that's the case, I would recommend, just either printing out a copy of that ordinance or citing the specific, statutory code if it's been added to the code. and then sending that in a letter to the tenant saying, hey, you have a requirement to provide me with documentation, and I ask that you do so.
Okay, thank you. So if a landlord wants to sell a rented single-family home and the lease is up this summer, what actions does the landlord need to take? Meaning, is there anything different than normal in this regard, like a 60-day notice?
Well, in that regards, there's a couple things at play. Actually, late last year, before this all arose, there was Assembly Bill 1482, which put in place new requirements for terminating leases and restricted a landlord's ability to terminate a lease, except in certain permitted occasions. Now, assuming that you fall under that and you're able to terminate your lease, the problem you might arise is if the tenant doesn't leave, then what do you do? And again, the problem is that you can pursue your unlawful detainer action, but currently the way things stand, the courts are not hearing those cases. Now, as things stand, again, that is, I think, changing, and they might begin to hear those cases soon, but for the immediate time being, you're stuck. So if it's something maybe later in the summer, it's, I think, a good chance the courts will be starting to move through that process, although there could be a backlog of cases, so it might take you some time. So that's kind of what landlords would be facing in those situations, is that they got one, they need to look at, can they terminate the lease under the previously existing criteria, and then two, if the tenant doesn't leave voluntarily, they may be have some trouble getting out and using the court system. So.
Okay, great. So here's another one. When tenants don't pay rent, you are allowed to ask them to complete a form that many cities have created, explaining why the tenant, cannot pay the rent. Is there anything that you can do to make them complete this form? And how can a landlord verify if a tenant can or cannot pay rent?
I'm not personally aware of any forms that either the county or city has. They very well may. But in terms of kind of making them complete the form, I guess, maybe you have an argument that that's the, quote unquote, reasonable documentation that you need to, kind of have evidence of that change in, the financial situation. And then in terms of verifying whether they can or cannot pay rent, I guess it depends on whether it's a commercial or residential tenancy. If it's a commercial tenancy and you have a business in there, then you might want to request cash flow statements, income statement. Residential tenancies, I guess maybe you would request recent pay stubs or some sort of maybe application for unemployment if they've lost their job. But I think it kind of depends on, what the particular tenancy at issue is.
Okay.
Yeah, and again, I think I'm not aware of any particular forms that is being actually required. I think those forms are typically maybe helpful to the tenants to supply the information or give landlords the information they'll need to make that determination. But I think, again, any sort of documentation that you may have would really, that would answer the question as to your ability to pay would be acceptable. It kind of goes back to the last question again. What does a landlord want to do to protect themselves getting into a lease? I think asking for bank account records and those sort of things that Ian mentioned, those are all useful. Of course, you want to do that, I think, whenever you're a landlord entering into a new tenancy, and not just in this context. So those are sort of general practices that you want to adhere to, I think, as a landlord to protect yourself, so that you don't get yourself in a situation with a tenant who can't continue to pay rent.
Okay, here we go, another one. If a party is occupying a property and has no lease and they're not paying rent, what are the requirements for a landlord to get the tenant to vacate the property? The tenant is not vacating the property and the escrow is being held up.
So there's no lease. Well, if there's no lease, again, I don't think that changes necessarily the analysis. Again, just because someone doesn't have a lease, you still need to get them out of the premises if they're not abiding by the lease terms. And so you're going to be faced again with the same as a landlord. And you still need to give your notice to pay or quit and go through the process. Again, you're going to be faced with some of the moratoriums on proceeding with those requirements. And then also, once you get to the point where you're ready to pursue an unlawful detainer action, the courts are currently not able to process that, so there might be some delays again. So again, as a landlord, if you're trying to get your tenant or whoever's occupying your premises out of the property, you need to perhaps be more use the carrot instead of the stick, and maybe try and work out something financially with those parties to get the tenant to cooperate and move.
Yeah, I think that's that's exactly right. And the only thing I would add is, there is, of course, that moratorium on unlawful detainer actions, but, and if you fall into that particular exception for actions necessary to protect public health and safety, then, possibly you can get around the moratorium. But if your particular factual situation doesn't have anything that would support, oh, this is necessary to, protect public health and safety, then that moratorium is probably going to prevent you from using the court system to get that tenant out.
Okay, going back to that other question that we had, Randy Freed mentioned that the LA City has forms, because we weren't aware if our city has them, but he was saying that LA has them. So here's another question. Is there an argument to be made that COVID is analogous to mold and may make a property uninhabitable?
Well, I think that's a good, as close an argument maybe as you have. Again, it's a situation that obviously I don't think you have the same concerns in the mold context that in mold traditionally there's always been an argument, well, this isn't really unhealthy, or is it unhealthy mold, and so therefore does it really make the property uninhabitable? Here, I don't know that there's quite the same argument as to whether COVID-19 is unhealthy or dangerous, but the bigger problem is really how do you show that it's there in your property, creating a problem. Just because there's a pandemic, that there's a virus out there in general, doesn't mean it's in any given location. Again, that kind of gets back to the damage and destruction provision of the lease that says, how do you show that something, as a tenant, how do you show that the property has really been damaged or destroyed? Because I don't know there's any tests you could do to show that it's there. Maybe you can go through and take some samples and show that it's on the surfaces of the property, but it is an analogous argument, I think, because you're talking about something that's more intangible and not easily seen, and is creating the same sort of problems that might be unhealthy, or people just don't want to use the premises because of its potential existence. So I think it's a very analogous sort of situation.
Okay, and here seems to be one of the last questions. Is there any money in the trillions proposed set aside to assist landlords to go after tenants who move and then refuse to pay rent that they didn't pay during this rent despite respite time given to them from all the other government entities? So in other words, did you understand that? Because I kind of stumbled over some of this.
I think so. I think the question is there funds available, such as through the PPP loans and that sort of source, to help, I guess, fund a lawsuit essentially to recover monies? And again, I don't, from my knowledge of the PPP loans, those aren't to be used for that sort of purpose. You can, as a recipient of those funds, you can, it's mainly intended to use to pay your employees, to keep your employees working. You can use up to 25% of the funds you receive towards other resources, such as payment of rent and utilities and those sort of things. But I don't know that the payment of rent would include recovery or pursuit of an action against a tenant who is not paying rent, because you as a landlord are recovering rent. So it might help the tenant again in meeting their rental obligation, but I don't know that's something that's going to help the landlord in chasing after a tenant who's not paying.
Another quick question. Can the rent be raised during this time? Like if somebody's lease is going to be renewed, is it okay to raise the rent, or under any other circumstances?
I think you can generally raise the rent under typically in accordance with the lease terms. However, there is, and Ian actually might be able to talk about this, there's a provision somewhere in the code that says that under emergency conditions, you're prohibited from raising rent. And I think that's actually something that that might be in place even before this. It certainly would apply, I think, to this pandemic, but may have even applied before that. But Ian, I think you'd looked at that at one point.
Yeah, that came up actually in the context of the Thomas fire. I think, I don't remember if it was a local ordinance or exactly what it was, but it was something along the lines of, while the governor's state of emergency with respect to the multiple wildfires was in effect, landlords were prevented from raising their rent during that period. I actually haven't looked into it with respect to the COVID-19 pandemic, and that's a really great question, something I'll look into. But you know, besides that, there's also the local city ordinance, I believe, Brad, it's in the city, that you know, prevents landlords from raising their residential rent above, whether it was 10% or it was 10%, or, and it was tied to, like, you know, 3% and some other metric, and I forget exactly what that was, but we had done something like that recently.
Right, as I mentioned before, there was a bit of legislation at the end of last year, even before this COVID-19 pandemic arose, that put limits on landlords' ability to increase rent. That was both the AB 1482, as well as the city had adopted some legislation regarding residential leases. So those are things to look at, certainly in terms of making sure you comply with those if you're a landlord looking to increase your rent during this time.
Okay, well, a couple more questions. Do you have, and I think you may have answered this, but you may not have, do you have any idea whether the eviction restriction will be lifted June 1st or soon thereafter? And if it is still a 60-day time period for them to move, assuming they have been there over a year? And the second part of this is, are they extending it to 90 days? I am in a counteroffer situation and need to know if possible. I think that's one of the things that maybe, Brad, you brought up, or am I misunderstanding?
Well, I think Ian sort of covered it, but my understanding is that, again, the way these unlawful detainer moratorium are written is that they go to a certain date, and after that date, or when the governor's executive order expires, then those moratoriums terminate. So I think basically, once we get to those dates, those restrictions go away. However, I think it's possible that they will continue, that some of those might be extended, and so you want to keep your eye on that. And then again, as to the 60-day waiting periods, 90-day waiting periods, again, I think there are some time periods that even once the moratorium go away, you do need to provide some notice. And I think that was maybe covered in what Ian had covered. But so there's not going to be anything that happens immediately, but some of these things are going to start to loosen up, I think, in the near future. But at least you'll start the clock running on some of these things.
So Crystal Pleiser, who's our government affairs director, she just sent a quick note that just said the state required rent caps of 5% and regional CPI. So she just mentioned that, and she's kind of our local expert on that particular thing. Another question, tenant using a damaged property claim due to COVID, couldn't the landlord then make a cross claim against the tenant, as the only way the COVID could get on the property is by tenant or someone they invited to the property?
I'm sorry, I missed the question.
Okay, so if a tenant using a damaged property claim due to the COVID, couldn't the landlord then make a cross claim against the tenant, as the only way the COVID could get on the property is by the tenant or someone they invited into the property?
Well, I think that's certainly an argument that's worth making. Whether that's a winner or not, again, that's one of those things that time will tell.
So just as a personal note, you know, most of us are not lawyers, and that's why we have these expert gentlemen with us. And so just for me personally, you know, I would say if you have any questions or concerns, don't pretend to be a lawyer. Call one of these guys. And I think that's it, Casey and Todd. Do you see anything else? We're good. So gentlemen, thank you so very much. I think Casey is going to ask you to send your PowerPoint presentations to her, if that's okay with you. And she'll go ahead and distribute them as she sees fit. And we just really, really appreciate your time and your knowledge.
Well, thank you for the opportunity.
Yeah,
Okay.
thank you guys.
Thank you so much. Okay, I guess, Casey, we're all done. Thank you all who participated. We had a big group. Take care, everybody.